one of the top 10 was the home office deduction, and you've covered it and such. And there can be a difference of opinion here. I mean, and the IRS may have already responded to Mr. Sullivan. He may already be posting the response, and I think that response may be, this will take a legislative fix as opposed to regulatory, and we can maybe have a difference of opinion on that, and we probably let Ways and Means figure that one out for us. How often do you come to that conclusion as you review as review the IRS code and the regulations that accompany the enforcement of the code as requiring a legislative fix as opposed to a regulatory fix? Because obviously legislative takes a lot longer.
Right. It really depends on the law itself. Quite often we are able to make adjustments. That's how we actually put out regulations. But actually our laws, the laws that we are given in the Internal Revenue Codes are usually very detailed. So most of the regulations we put out are interpretive regulations. So we're just kind of interpreting what is in the code itself. So there are times that we are able to do things through regulations, and we do apply regulations when we can. But there are times where we are limited by the code or other sections of the code from doing something. In the case of the office and the home deduction, that's kind of where we are with that particular issue.
Okay. Mr. Wagner, I'm going to read something that staff actually prepared regarding after they reviewed some materials from the IRS, and they said, and in your statement, that IRS regulations promulgated by IRS are not subject to review under RegFlex, the Regulatory Flexibility Act, because the agency is only allowed to consider the administrative impact of compliance with a regulation, not the tax burden itself. So you're making this distinction. You're saying, well, sure, it's going to cost a small business a whole lot of money because they conduct all their business out of that spare room in their house, but our regulation can be so complex it can't comply, so they don't go ahead and attempt to get the deduction. But that wouldn't be the bottom line for them is, yeah, it is their bottom line. It does impact. But what you're saying, there's a distinction between the administrative compliance cost and the consequence of the tax burden.
Right, because when you look at the actual code itself, the law itself, if that's causing the burden, and we're not considering that under RFA, what we're looking at is if we actually make adjustments in the regulations that actually add to the additional burden that's caused by the tax law itself, then that's what we would consider. So we're saying the administrative burden that we add through a regulation is what we would consider under the Regulation Flexibility Act.
Yeah. And I understand that, and I think in the discussion it may be esoteric, but I think to the small business, it's that bottom line. I mean, it's a burden because the regulation does not allow them to take advantage of a deduction, which obviously does affect their livelihoods. Thank you very much for your responses, and thank you, Mr. Westmoreland, for your patience, and I recognize Mr. Westmoreland, the ranking member, for his questions.